after he finishes. Thank you.
Assalamu alaikum, Your Excellencies, distinguished guests, ladies and gentlemen. This is the last presentation on the second day of the conference. Thank you very much for staying, and thank you very much to the Centre for inviting me to speak on today's topic. To introduce, I've got 10 minutes to present on the topic of arbitration on Saudi construction projects. This is intended to be a very quick survey of what arbitration is used on Saudi construction projects. It's not just a presentation on Saudi arbitration, because of course Saudi arbitration is not used on all projects here. So one of the topics that I wanted to talk about was the extent to which we're seeing trends one way or the other towards Saudi arbitration, whether that's institutional or ad hoc, and foreign arbitration and where that is. And I'll conclude with a suggestion of what the opportunities are, in my personal opinion, for Saudi arbitration to take over some of that space that's currently occupied by foreign arbitration and other forms of dispute resolution. My presentation is a series of diagrams. I apologise that it's slightly out of focus there, but perhaps you'll have an opportunity to read the slides after the conference. I also apologise that they're not in Arabic from the start, but as you'll see, there are Arabic versions of these slides as we go through. I thought I'd start with a diagram that is hopefully familiar to many of you, which is a typical contract structure on a construction project anywhere in the world. So here we've chosen an EPC contract structure which has a slightly different set of lines and boxes from, say, a real estate project where the employer does the design. For those with keen eyes, you'll also notice that the EPC contractor is a joint venture, which is the case on very large projects, and Saudi Arabia has that simply because you need more than one to build the scale of, say, the Riyadh Metro project, the largest metro project in the world. So the lines between the boxes with the owner at the top are intended to be the contracts themselves. So between the owner and the EPC contractor, you would have the EPC contract, or the main contract. Between the EPC contractor and the subcontractors, you would have the subcontract. And then going across from the EPC contractor, he has engaged a design consultant under a design services agreement or a similar named document. And within the joint venture, there's likely to be a joint venture agreement. So the reason I'm talking about this is to give you some background on where construction disputes might arise within that contract structure, and then we'll come back to what sorts of disputes they are in terms of procedure and arbitration. Again, I apologise if this is not readable, but the red box that's highlighted there says main contract disputes, and it says what sorts of disputes tend to arise on main contract issues. Now, my colleagues, in particular Adrian, has talked in detail about time, cost and quality, and they're manifested in these sorts of issues. So I've listed payment issues, variations, extensions of time, liquidated damages, defects, performance. So they're the sorts of issues that can arise between a main contractor and an employer. At the next level, which is the subcontract level, you also see similar types of disputes because, of course, the main contractor has simply passed down some of the scope that it is obliged to perform to particular subcontractors. So the issues are likely to be the same. Moving across to the design services agreement, this is a slightly different arrangement where you have a consultant designer preparing drawings or other design that the contractor then builds itself. Again, you might have payment disputes, but you might also have issues around design defects, and sometimes you also have issues around delay and additional services. And then finally, within the joint venture agreement, so this is within the EPC contractor itself, you might have arguments about scope allocation, you might have arguments about profit and cost allocation. It really depends on how well the joint venture agreement was drafted in the first place. And often what we see is that joint venture agreements are not always done well because often they're signed at a stage when the joint venture doesn't even know whether it's won the project. They might be at the bidding stage. So things like scope allocation tend to be in dot points or similarly not defined for the purposes of running, say, a 2 or 3 year project. So this is the Arabic version of the slide. Hopefully you can read this. So just to recap, we've looked at the contract structure, we've looked at where disputes typically arise, and we've looked at the substance of those disputes. We haven't yet looked at the procedures around them, so we'll come to that. I think it's also important to discuss briefly what makes Saudi construction disputes different. So we've heard from other speakers today about the international perspective, trends in construction arbitration. We've heard about common issues that arise in relation to quantum and the assessment of damages. But how is Saudi different from, for example, the UAE, or if I can broadly call it the West, where you might see English projects or US projects? How is Saudi different to those sorts of jurisdictions? Well, the first point to make is that the scale of projects is huge here. It's a playground for construction lawyers, and complexity of arrangements that go with that. For example, I mentioned Riyadh Metro, where you've got 3 packages, you've got contractors coming from all over the world to join together to build those 3 packages. And all of those participants bring their own perspectives on what they're used to in terms of legal principles, whether they come from civil law countries, whether they come from common law countries, what their expectations are around dispute resolution. The second dot point there is the greater level of direct procurement by government. Particularly in the infrastructure space, we're seeing government procuring assets to a large extent here, more so than I think, than many other GCC countries. And the tenders law in particular has a much greater role on legal issues here than it does in other places. One of the features of the current tenders law, and I will say the current tenders law, is that it doesn't allow arbitration by government ministries. So those matters tend to go to the local courts, and in particular the Board of Grievances. And the final point I'll make about what makes Saudi construction disputes different is the impact of Sharia. So it probably won't surprise the Saudis in the room to know that most Western companies coming into Saudi Arabia don't have a fundamental understanding of Sharia. It's something that they perhaps try to educate themselves on, but they come to it with a degree of uncertainty, and in my view that leads to them wanting to settle disputes more rather than running them all the way. So we tend to see less matters running all the way through to award in arbitration, even if that arbitration is overseas, when the governing law is local law as opposed to something else. So we're back to my diagram, and here I've put red circles where the arrows were pointing before as to where the disputes were arising. So typical disputes, as I said, arise at the main contract level, the subcontract level, at the design services agreement space, and also within the joint venture. So what do those dispute processes look like? And again, this is my own personal view and that of my colleagues, having worked in this jurisdiction for quite a while. So that is impossible to read, but I'll tell you what it says. So within the main contract, you have 3 different levels, in my opinion. First of all, you have to look at what the government projects results in. Then there's state-owned entities, Aramco, Ma'aden, and then there are private projects that are being procured by private developers. And all of those have different typical dispute processes. I mentioned before the impact of the tenders law. So on government projects here, and by that I mean direct procurement by government, there's no arbitration. On state-owned entities, typical Aramco forms, for example, we see ad hoc arbitration within Saudi. So that's not institutional arbitration such as the SCCA, where you have a prescribed set of rules. It just says arbitration in the kingdom, and that means that you default back to the arbitration law, and the arbitrators therefore have a fairly broad discretion as to how they run their own processes. Finally, there's private projects. So these are, for example, real estate developments by Saudi developers who then engage contractors to build, let's say it's a hotel or a mall. My view is that we're still not seeing Saudi arbitration there, that more often than not, depending on where the developer comes from or what they're used to, or indeed what the contractors require, more often than not, we're still seeing Dubai arbitration there, perhaps with a local set of arbitration rules such as DIAC. At the subcontractor level, it's fairly similar. So I've written there, follow the main contract. Of course, that's not possible for government projects because government projects at the main contract level go to the Board of Grievances. That's not available for private parties as such, so there have to be some modification there. But as a general rule, the subcontract dispute resolution clauses follow the main contract, and indeed sometimes try to combine the arbitration processes so that you have back-to-back arbitration. In terms of the design services agreement disputes, often what happens here is that you have what I might call a foreign supplier. You have a company that's based overseas. Perhaps a lot of the design work is done overseas. And many of those companies, particularly architects, are in a position to be able to dictate what large parts of the contract say, and indeed what the dispute resolution clause might say. So we're not seeing Saudi arbitration at that level at all. Again, you might see a Dubai seat there if you're lucky, and you might see ICC rules. That's typically what's happened in the disputes that we've seen run recently. And then finally, the joint venture agreement. What sort of dispute processes do you see there? Well, a feature of the joint venture agreement is that it's usually a group of companies that are coming from lots of different countries. One of those companies might be a large Saudi company, so NESMA, for example, on one of the packages of the metro, but the other companies might come from, let's say, Turkey, Italy, India. So they'll usually choose a neutral seat, as they put it, which might be Geneva, London, Singapore. Again, not Saudi arbitration. And again, we would tend to see the ICC rules as the most common set of rules that's used. So to recap, we've now looked at the different dispute processes in all of those levels of dispute within a construction project. This is the Arabic version of the slide, and now you'd be pleased to see we're going to bilingual slides when I talk about where are the opportunities for Saudi arbitration in respect of these projects. So in terms of government projects, I think we're starting to see a trend, indeed draft tender laws that say that government entities can enter into arbitration. So I've put there local courts moving to Saudi arbitration, and it will be fascinating to see that trend over the next 6 to 12 to 2 years. Obviously, Saudi arbitration is not institutional arbitration. It may be that the prescribed form in, say, the Public Works contract, the next version of it, might require not just Saudi arbitration, but SCCA arbitration, which would be a great thing. Personally, I don't think ad hoc Saudi arbitration is the greatest way forward, but other people might have different views. In terms of state-owned entities, they're already having Saudi arbitration, but it doesn't specify institutional rules. So I think the challenge for institutions such as the SCCA is to convince those entities that the SCCA rules are those that should be adopted in preference to the other options, because of course you can still have Saudi-seated arbitration and still have all the benefits of local enforcement, even if you choose the ICC rules. So the SCCA has a challenge on its hands to convince people entering into contracts that its rules should be chosen over the other options. In terms of private projects, as I said, foreign arbitration is the most common, and I think it should be an easy win, especially in the context of conferences like this, to show that Saudi arbitration is becoming more sophisticated, that we're getting a greater pool of arbitrators here who can compete with what would happen in Dubai, and that all of the infrastructure around arbitration is achievable, and that's a message that should be able to be sold to local developers. Where I see less of an opportunity, or perhaps no opportunity, is in the last two categories, which are around the design services agreement and the joint venture disputes. And the reason for that is, for example, the joint venture disputes, if they have a Saudi contractor within that joint venture, they'll still be looking for an independent seat because they'll see that as necessary for them to be able to have a fair resolution of their disputes. So hopefully that's been a helpful overview. I'll hand back to Mr. Moderator.
Thank you.
We'll go from there.
Thank you very much, Ben. I think